Hi, this is estate planning lawyer Michael Pevney. I create estate plans for families. In this video, I'm going to talk about the 3 places you should not be storing your original estate plan. When I create estate plans for people after it's signed by a notary, I always give the originals to the client. I always retain a copy for myself and we scan a copy after it's signed, but the client always keeps the original signed documents. And often I get the question, where should I store these? Where should I keep these? And so I'm going to talk about 3 places where you probably shouldn't be keeping them. The first is a safe deposit box. We often think that a bank safe deposit box is a great place to store important things. Not necessarily so for an estate plan. A safe deposit box is essentially a little space that is being leased from the bank. And only the tenants or the people on the lease have the right to get into that safe deposit box. So if maybe you and a spouse are on that lease and something happens to one or both of you, nobody's going to be able to get into that. Sometimes we need to get into that box quickly because there's a healthcare emergency, and things like an advance directive or a healthcare power of attorney that's included in an advance directive are inside that box. And good luck getting in that box on a Sunday or after 5 o'clock or before 10 o'clock on any weekday. You know, the joke is that banker's hours, banks aren't open that often. So good luck getting in there. You're not going to be able to do it. Will a copy suffice? Maybe, maybe not. But the originals should not be stored in that safe deposit box. Also, I usually create my estate plans around a living trust. And the whole point of most of the trusts that I create is to avoid probate, which is the government-run and government-controlled asset distribution program, because probate is time-consuming, it's costly, it's not private, and there's a lot of lack of control that you have over your assets and how they're distributed. Now, if the people that need to be in control of that trust after you're gone or after you and your spouse are both gone aren't a part of that lease to that safe deposit box, we're going to have to open a probate case in court, which defeats the entire purpose. It's going to take months to get orders, to get somebody in there to drill open that lock and finally get the trust out. But you still will have opened a probate case, which will be costly and time consuming. So the safe deposit box is not a good place to store those original estate planning documents. Second would be a locked safe inside the home where somebody else doesn't have the combination. Obviously, a safe is a great place to keep things safe. They can even protect from fire and water damage and obviously theft. But if the people that need access to that estate plan, to those documents, whether they be powers of attorney or a trust, at the time when it's really needed, if they don't have the combination to that safe, they're not getting in. So if you do put that estate plan inside of a safe, it's very important for the people who take over the trust after you're gone, for the successor trustees to have the combination to that. Otherwise, nobody's going to know where they are. Nobody's going to know how to get at them. The people need to know where the documents are stored and how to get at them. Obviously, sometimes there are privacy concerns with an estate plan. I personally don't think that there's that much of a privacy problem with the estate plans that I create. I do not put social security numbers in there. There are names, there's addresses, there's the way you want your estate distributed, but there's not the kind of information that's in there that might not be in a bank statement or other documents, bills and statements that you might get. So the second place not to store an estate plan is a locked safe in your home. If other people do not have the combination to it. The third place not to store an estate plan is your lawyer's office. The original copies should not be at the lawyer's office. Similarly to a bank, if you need those original documents in a pinch and you need to get them quickly and the office isn't open or it's the middle of the night, you're not going to be able to get those documents. It's important that the client retain the originals. Yes, a lawyer should keep safely at least a digital copy of those documents, and I do, but the originals should not be with the lawyer. You're also not going to be able, with a trust, to get them from a court because we want to keep these things private and out of court. They're not going to be filed or lodged with a court because we want to avoid that and avoid probate. So, where should you keep these original documents? Now, I usually tell people that you want to keep them safe, but not too safe. Like I said, I don't think there are huge privacy concerns with the trusts and the documents that I create. I keep mine in a binder on an upper shelf in the closet. The people that need to know where they are know where they are. They're not impossible to get to. They're not sitting in a bookcase when you walk in the house, but they're kind of tucked away, and unless somebody's really snooping around, they're not going to find them. And the people that need to know where they are know where they are. So that's just a little information on places you should not be storing your estate plan. So if you have any questions about this or anything else related to estate planning, you can set up an appointment to meet with me for free by going to ocestateplanlawyer.com. Please feel free to like or comment on this video, and thank you very much for your time, and thank you for your attention.